Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. One of the presenters of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hello, my name is Andrew Struve. I'm a trial lawyer with Hooper, Lundy & Bookman PC in San Diego, California. And I'm here with my longtime friend and colleague, Susan White, who is a trial lawyer as well at the Buckhalter firm in Los Angeles. We've worked together on many occasions, including in trial and arbitration and extensive pretrial proceedings. And so we know each other's styles of how to do these things, and hopefully we'll have something useful to impart to you today. The title of our presentation is You're Hired, Now What? ? What we're intending to do today is to provide some basic considerations at the inception of a litigation matter. So we have a checklist, and this will be our gift to you. And although we've authored it, I should point out that we also use it because it's very easy to overlook one of the items on this checklist, and missing any of them can be a serious problem. And so what we've attempted to pull together here today is a guide, like I said, a checklist, to initial considerations on any new matter. It's particularly tailored towards litigation. Some of it may be useful to others, or to those of you who have a client. You may practice in a different area, but a litigation matter has come in and you give it to a litigation team to work. This will give you a little guide to monitor their progress on the case. So why do Susie and I use this checklist, even having written it? Because checklists serve a quality function that has actually been proven over the last number of decades to have a very important effect on safety and performance, right? And so two analogous fields are medicine and aviation. In medicine, there have been numerous surveys that I could cite you to, but won't, that have shown if you go through a surgical checklist, even in pre and post, it will have an increased beneficial effect on quality. Just by one example, there was a doctor, her name is Apgar. She was one of the first very senior female anesthesiologists, taught out of Columbia University, and she invented something called the Apgar scale. She didn't name it after herself, but a grateful world of medicine named it after her. And this was the way to assess the functioning of an infant, both immediately after birth and then I believe it's 2 minutes later. And it assessed 4 main physiological functions of the infant on a scale of 0, 1, and 2. And it gave the medical team the ability to immediately recognize what needed to be handled in the immediacy. And the effect on reduction of infant mortality was dramatic, and now it's used everywhere. In aviation, as aircraft became increasingly complex, the use of checklists prevented people from missing something, or at least reduced the number of misses. And much has been written in that area. In the old days, piston aircraft, not computerized, fewer functions, you could kind of do it with less formality. As aircraft became more complex, and indeed today they're a higher level than complex in the industry, it's known as complicated, a way to ensure safety was to follow what they use as an audible checklist. And this was designed to prevent such silly errors, and unfortunately they do happen still, as taking off or not taking off is really what happened with the flaps in the wrong setting. So the checklist will also give you some reassurance. It'll improve quality, it'll improve safety. And we're going to trade back and forth on the topics, but I'm going to take the first couple. It may sound obvious, you'd be surprised how many times people forget to do it. Before you touch any of the controls on a new case, make sure you clear conflicts using the procedures set by your own firm or those set by the general ethical standards, etc., and requirements if you're an independent practitioner. A failure to do that, among other things, if there is a conflict that arises and you perform any work for the new putative client, you may wind up having to withdraw from the existing relationship, which will not earn you any great thanks from whoever in your firm had that existing relationship. There have been cases where in pre-litigation or at the inception of litigation, a rather dirty birdie on the other side, usually the actual party in interest, may conflict out other law firms simply by calling them and asking them a few questions about how they could help. I have known it to occur in the family law context, where one might pick off the 4 or 5 most regarded practitioners in their locality and have a little conversation with them, and now their spouse could never hire them, and they may have had no intention to hire, okay? Last thing I'll say is there is case law in the state of California where Ms. White and I practice that says that the actual value of legal services performed while under a conflict is 0. You could do 6 months of work while unknowingly operating under a conflict. You could send out all kinds of bills. Not only would you be potentially liable for malpractice, which is harder to prove than you'd think, but all those fees have a string on them and they're all going back. And by the way, in all likelihood, that could happen with the matter which conflicts you.
And if I can just
Please.
I'll first start by saying hi and thank you for joining us. But the other issue with conflicts is even if it's not, if you don't catch it yourself, you know, because if a conflict does exist, the other side, especially when you're in complicated, heated, sometimes very acrimonious litigation, they'll move to disqualify your firm. And if they know of grounds for doing so, again, now you've started this, and you've done a real disservice to your client if there are in fact grounds for that, because it's a mess to do it. It does not bode well for, you know, how the judge may view the client in all of these situations. So it's important, you know, another reason why it should happen at the beginning to make sure everything's clear.
And so to be mindful after you've clarified using your internal systems, which hopefully are excellent and also have redundancies in them, that you don't have an actual conflict. And actual is a term of art here. Then you have to think about, do I have a business conflict? Would taking this matter on offend other existing clients of the firm? I practice mainly in the field of healthcare. Would taking on a representation for a provider in a given area offend payor clients? If we go in and take the position that a certain treatment modality is medically necessary on behalf of a provider, would that offend payors who have a very different view of, say, proton beam therapy being medically necessary and hence compensable? Something you have to look at. Reputational conflict, also something you have to look at. The stories are innumerable. The Nazi gold cases, right? Very, very careful on taking on that kind of thing because there are obvious stakeholders, at least they should be obvious, who would not want to be involved with a firm that was representing certain clients in that context. I deliberately picked that one because those cases passed a few decades ago. But you can imagine numerous other scenarios. Speaking from experience, one case that Ms. White and I worked on was originally assigned to another law firm, and it turned out to be one of the more remunerable cases I had ever worked on in terms of fees and collections and result. It had originally been assigned to another law firm who had just begun to work on it, and then we got wind of it and pointed out to the to-be client CEO that that law firm, which had been selected by the private equity owners of the organization, had essentially accused our CEO, our client's CEO, of being a liar in an unrelated prior case involving a different company. You can imagine what his reaction was to using them as counsel in the new matter. And I took great pleasure in seeing an instruction for that firm to have all the boxes immediately transferred to our office. Reputational conflict, positional conflict. I offer that for your consideration. The only thing worse than an angry client, by the way, which are bad enough, is an angry partner. You got to see them every day. And then if they're on the compensation committee, I'll let you draw your own conclusions about what happens. So you've cleared conflicts, you've reassured yourself that you have no existing business or potential business conflicts, reputational conflicts. I'll now turn to Local Rule 1, as it was referred to in a jurisdiction in which I practiced. There was no Local Rule 1. Lawyers would seek continuances from the court of initial appearances, and they would invoke Local Rule 1, and the judge would know exactly what they meant. It meant, I haven't been paid. I need to continue this until I get paid. Local Rule 1, of course, not written anywhere, was make sure you get paid. You will find matters coming to you where you have serious doubts in the inception about the client's ability to pay. Well, the number one rule of holes is stop digging. If it doesn't feel right at the outset, it is unlikely to improve. You need to give the prospective client a clear-cut understanding of what the litigation may involve and entail, and make sure they have the appetite for it, and give them some options so that they don't feel blindsided later, so that you can have a successful relationship from the outset concerning expectations, cost, length, discovery, and any other things which may arise. You get clear at the outset.
Well, and expectations for the client is so important. Sophisticated clients understand how expensive litigation can be. People that maybe don't litigate very often and get sued have no idea. So not only is it helpful often to provide budgets right from the outset of, based on this, and we're just getting started, this is how we would envision that this could cost, X amount of dollars. It's also good to keep those budgets, refining them and updating them, because things change. You might actually have if you're a defendant, if you have a plaintiff's law firm, they actually might be perhaps a contingency firm that really doesn't do much discovery. Or you could have the highly litigious plaintiff who has the no stone unturned approach. And so once you're able to ascertain that, it's helpful to then update the budget that you've given to the client so that they continually have expectations that all of a sudden they don't get hit with a bill for $250,000 in 1 month and saying, what the heck have you guys been doing? So.
Susan and I, Ms. White and I, could give a 60-minute presentation or possibly even a longer one on whether to give a budget or not. It exceeds the scope of the time that we all have today.
Right.
At the end of this discussion, we'll give you our contact information, and after we clear conflicts, we'll be happy to discuss the issue with you. I have my own opinions about it, but they vary. Okay, so you've decided that this case is something you can take on for the reasons already discussed. What next, Susan?
Well, the next step is, assuming you're the defendant, well, let's even back up. If you're the plaintiff, first and foremost, you have to make sure you have the proper parties that get served with the complaint. So if it's an individual, obviously the individual needs to get served. If it's a company, they have a agent of process that accepts service for them. If you're, for example, in a dispute with the other side, the company, let's say, and they already have counsel, you may want to approach that counsel and let them know you're filing suit. Would they accept service on the company's behalf? Those kinds of things can make it easier for you as the plaintiff, and it can also make it easier for you if you're the defendant. There's reasons why you may want or not want to accept service on the behalf of the defendant if you're their attorney. But above and beyond, once that service has been completed, and every state has different rules about that you need to keep your eye on, is the date of service, because that is when the clock starts ticking. And I know that this sounds very basic, but I can't tell you how many times I'll get an email from a client saying, oh, we got served with this. And I'll say, well, when? Oh, a few days ago. I go, no, was it 3 days ago, or was it 4 days ago, or was it yesterday? Like, specifically, we need to know exactly what day you got served with this, because sometimes they haven't put it on the summons until after they do it and then submit it to the
Sometimes
courts.
their response is due 30 days after service, and they contact you on day 27, and then you have a little bit of decision making to do about how to approach that. As a plaintiff, even from a precursor step, is you've got to figure out where you'd like to bring the action. A lot of people assume, without necessarily thinking it through, they sort of go to what they consider their home go-to court. There are often other options. I'd be hard-pressed to think of a matter where you wouldn't at least have some choices. If what you ultimately settle on is not necessarily what the other side might expect, they may agree to it anyway. A number of types of litigation can be brought, for example, in the federal court in New York or in a state court in California. Mm-hmm. Who knows? You need to play through and think through the options. I've had people say to me, well, we have to do this. There's only one choice. There's never only one choice. There may be only one good choice, but you certainly have to explore the options and the potential pros and cons. And of course, where you file is an issue for client disclosure and consent. Now turn to some of the more basic elements. These will seem obvious. You learned about them in your first semester of civil procedure. You have to ask yourself about them every time you get a new case. Existence of subject matter jurisdiction. Sounds obvious. Not always that obvious. Subject matter jurisdiction cannot be waived, as you know. I am aware of a case handled by a very fine law firm that was about a year into litigation. A summer associate very trepidatiously raised at a team meeting in a venue where this associate probably assumed that summer associates were meant to be seen but not heard, that he was of the opinion that the court lacked subject matter jurisdiction, and he was absolutely right. I leave it to your imagination how the client felt about this. I leave it to your imagination how the client felt about paying bills for litigation, all of which was meaningless. It can't be waived. Everything you've done is a nullity, except, by the way, any admissions you've made, any inconsistencies in the pleadings. Anything you stated in a pleading could lead to an argument that a subsequent pleading in a different venue is a sham complaint. And if you don't know what a sham complaint is, you will learn very quickly. Another question on the defense side, you have to ask yourself, not so much on the plaintiff side, right? Because the subject is personal jurisdiction. If you file a case in some esoteric location in which your client would not otherwise have been subject or be subject to personal jurisdiction, You will have consented to it. I can file a case on Ms. White's behalf on the island of Tonga, and she will have consented to their jurisdiction despite never having visited it, to her deep chagrin. On the defense side, please, please make sure you think about personal jurisdiction and don't waive it. The worst is you're some period of time into a litigation and some other lawyer from some other firm or some internal lawyer that works for the client says, gee, why are we there? We don't have personal jurisdiction in, say, the state of California. And then explaining why you never considered or raised the issue would not be an enjoyable function. You'll remember general and specific jurisdiction. If you do a single act in a location and the litigation arises out of that act, that's specific jurisdiction. If you're silly enough to name your company something really big like, I don't know, International Shoe or Worldwide Volkswagen, you're probably subject to general jurisdiction if your activities in the state are continuous and pervasive enough that you have a presence in the state such that you could reasonably be expected to be hailed into court in that jurisdiction.
Well, and if I could add, on the personal jurisdiction front, having litigated that issue for a client, a Canadian client of mine was sued along with several of the individuals that worked with the company. The company certainly was operating in California, Los Angeles, so there was no issue really with the company, but we were able to successfully have dismissed a couple of the individuals who also had been sued because of a lack of personal jurisdiction in Los Angeles County. So, you know, and that's a huge issue sometimes for clients, is if you can eliminate any type of personal responsibility that one of their employees may be facing by getting them out of the case. And that's the result. Unless they wanted to, and we knew they didn't want to go up and sue them in Canada. So we knew that was an actual win, case dispositive win for certain defendants. And so that can be very, very important, yeah.
So the next consideration we'd offer for you is removability of the action. Logically, one would think that's a consideration for the defendant. It's also a consideration for the plaintiff when you are contemplating filing in a specific jurisdiction. Would the case be removable? That's not a reason not to file it. It's just something to be aware of. And if it exists, you let your client know in advance so they're not surprised when the notice of removal comes in. Removability is particularly important in a number of contexts, one of which is the timing to do it. It's very tight, it's very strict, and it
cannot be extended.
And cannot be extended,
right?
Because it is jurisdictional. It can't be extended by agreement of all the parties and an order of the judge if she were silly enough to do it. And don't take my word for it, but recollection serves. It's something like 5 days after your responsive pleading would be due in the state court. You do not want to waive that, because again, that mythical other lawyer from another firm who comes in and observes this thing later in the case, or somebody inside will say, well, gee, wasn't this case removable? And you say, wow, I never thought of that. Wow, it may have been. Oops.
Well, and the practice area that I'm in, I specialize in insurance recovery. This is an issue that comes up pretty much in every case. The thought about it, either because if I have my druthers, I want to file in state court on an insurance case. But if there's diversity with the insurance company, they 95 to 99% of the time will remove the case. There is still those small percentages that they don't for whatever reason, and I'm sure they have reasons for it. So it's still worth it to me to file in state court because I'm choosing where I want the case to be, even if I don't have the ability to stop a removal. But there's also a situation where there's been times, and based on the jurisdiction we're in, that we think federal court is where we want to be, and because there's diversity, we just start the case there and then we eliminate the removal issue. So,
agree with all of that. Special considerations about removability, and time prevents us from going into detail about any intricacies in them, and there are some offered for your consideration. You will test for removability, right? A federal cause of action or an absolute diversity of parties. Diversity of parties is very easy in that context. Look on each side of the V, and if every one of the parties is a citizen of a different state, then you likely have diversity. A citizen of a state is not as easy as you might think to determine, and particularly in testing for diversity, if you have an entity that is, say, a limited partnership, there's often a drill down on testing the diversity of the members of the partnership. Federal question jurisdiction, you'll often have a case that has a federal claim and also has state claims with it. The federal question will give you the hook on federal jurisdiction and should give you generally removability. The state claims will come along. When I learned this, it was called ancillary or pendant jurisdiction. Now they call it something else. I think it was 1367 of 28 United States Code. You can bring the state claims along with you, but know that if you are successful in dismissing the federal cause or causes of action, the federal court retains the right to continue to exercise its jurisdiction in a properly removed case over the state claims. In reality, it almost never does so, and you're going to go back to state court. Now, is that a reason not to remove? No, because as one came across my own desk this past week, we had a RICO claim that I happen to think is absolutely silly. Racketeer Influenced and Corrupt Organizations Act, for those of you unfamiliar with it. And I would rather have the federal court shoot that RICO claim in the head, and then the state claims will deal with in due course. That's not always what one wants. I would also caution in the diversity context, and particularly in Ms. White's insurance context, sometimes a plaintiff will attempt to destroy diversity by naming sham defendants. This is a complicated area. If you think you have a sham defendant, I refer you to the treatises on knowing what one of those is or may be. You may want to remove anyway. You will be greeted by an order to show cause why the matter shouldn't be remanded, and then you'll get to litigate in front of usually the magistrate the question of whether the defendant is indeed a sham defendant. If they are, they get stricken, and you're good to go in federal court. If they're not, you're remanded, you're going back. Removability, at the risk of pointing out the obvious, client decision, not your decision, client decision, okay? God help you if you exercise that decision unilaterally, whether to remove or not to remove, just as important. And you draw a judge that for whatever horrible reason decides they're not predisposed to your client or its legal or factual point of view, you will have wanted to disclose and discuss. And of course, disclosure and the obtaining of consent, and this applies to every area where we say today that it's a client decision, it's not just enough to obtain consent. It's like in medicine, it has to be informed consent. Nice idea to document client consent decisions in writing. You'll probably never need them. If you do, you'll thank God for them. Last issue on removability. Sometimes you have removability under the federal question doctrine where no federal cause of action is pled. How can that be, you ask? There are certain areas where something exists called super preemption. In other words, where cause of action is pled under a state law claim that arguably should only exist under a federal claim. Go ahead and sue your ERISA plan administrator for denial of benefits under an ERISA plan. And even though you never mention the word ERISA and you make it breach of contract or something, it may be a super removable claim. I refer you cordially to the treatises for a discussion of that. It's tougher than it looks, but please try not to miss it. Oh, and one last thing, I'd be remiss. Class action context. Check removability under CAFA, the Class Action Fairness Act. It does not require complete diversity. It requires only minimal diversity of citizenship. It also exists, as I recall, regardless of diversity, if the defendant has been subject to a class action on similar facts within a prior period of time. And I won't attempt to recite from memory the number of years, look it up. But in a class action, you want to consider CAFA removability. And now I'll turn it over to a very big one for Susan, which is arbitration.
So talking about arbitration and arbitration agreements, you're going to find them in contracts between the parties. There may be an arbitration provision in an insurance policy. And so that begs the question, if there is one, do you want to figure out a way to mandate it or avoid it? And it is an interesting subject because, for example, if you're the defendant, you get sued, you can go to court and do what they call a motion to compel arbitration, citing the various contract that demands the arbitration. And a lot of times the courts will either dismiss or at least put on stay so that the parties can arbitrate. Andrew and I actually had a case where we were the plaintiff, had sued in Louisiana. We sued more than one insurance company. One insurance policy had an arbitration agreement. But we thought, you know what, we don't really want to piecemeal this litigation against the two insurance companies and just sued them both together. And the insurance company never invoked the arbitration agreement. So away we went. We were in court. So even though there was one that they likely would have been successful had they tried to stay it for purposes of arbitrating. And it would have cost our client twice the amount of money because now they're in two different forums. It was funny because when we were successful in that case, we actually asked them, why did you not invoke the arbitration agreement? And they were like, we were so confident that we were going to win in court that we didn't think it mattered.
Oops.
Oops, exactly.
Yeah. One other thing about arbitration that I will mention very briefly, and I want to keep this moving because there's a lot on this pre-flight checklist. I had a case come across my transom, brought in as outside general counsel for litigation for a client, and they had one pending case. The independent contractor agreement at issue had an arbitration provision, and it occurred to me, why the heck didn't they move this alleged workplace discrimination? Yes, it was an independent contractor agreement, but just assume that. And I would have ordinarily removed it, and they were forced to do a bunch of backfilling about how arbitration has its drawbacks. Yeah, right, I let them get away with it, although it was my obligation to mention to the client that I was of the opinion they'd missed the issue. Oops. So you really do want to see if there's an arbitration agreement at issue. And by the way, or are you the third-party beneficiary? Is your client the third-party beneficiary of a contract that has an arbitration agreement that they could arguably invoke?
Can I add one more thing before
yes.
we move on?
Oh, yeah.
Because it just occurred to me. The other thing, too, is let's say you have that knowledge that there is an arbitration agreement. You've gotten sued in court, state or federal court anyway. And you want to see how it plays out. And then if things don't go your way in the court proceeding, you decide, oh, now I'll invoke it. That could be very problematic. There can be a waiver argument if you decide to go down the litigation path without demanding and moving to compel arbitration. So.
And there are a lot of niceties that go into that. One of the more humorous ones is you look at appealability of a denial or a grant of a motion to compel arbitration. I've had a case in the last couple of years where there were two plaintiffs, moved to compel arbitration as to each, granted as to one, denied as to the other, and my opposing counsel was less than delighted to learn that a denial of arbitration in California is immediately appealable as a matter of right, and a grant is not. So that poses some interesting appellate and jurisdiction issues I'll leave for another day. I want to go into briefly considering, and again, client consent, informed consent and disclosure. The availability of pendente lite relief, right? Now you say, well, look, I didn't take Latin, I didn't go to Catholic school. What it means is interim immediate relief, right? And it's something to consider at the very beginning of a case. And when you consider it, is it available? Is it appropriate? Will it get granted? You look at this as both a plaintiff and a defendant. As a defendant, your client may be served with a complaint accompanied with an application for an immediate temporary restraining order set for the next morning. Oops. That poses some challenges and makes for rather a late night. Pendente lite relief, temporary restraining order, injunction, Writ of attachment, we could do a 2-hour course on writs of attachment and how complicated they are. Do consider them. Receivership, do I wish to attempt to put this opposing party into a receivership? What criteria would be met? What would be the effect on the business? How would it benefit me? Or would it benefit me, right? And also involuntary bankruptcy. That alone is a very complex topic, but you can take a litigation, you can put the other party in appropriate circumstances into involuntary bankruptcy. It requires the participation of another creditor or putative creditor. And if you do have a bankruptcy like that, you initiate the bankruptcy, and then you can move the litigation over to the bankruptcy court, usually as a non-core proceeding. Last thing I'll say about injunctive relief in TROs. Imagine yourself in state court. Your client has just been served. It's a state court cause of action. They're going in for a TRO the next day. It might be granted, right? But the case is removable. Here's one thing you can do. Station a colleague over at the federal court with a notice of removal. If the court goes ahead and grants the temporary restraining order, having done the appropriate research and making sure you can do this, have them walk into the federal court and remove the case. Your TRO goes bye-bye, in most cases. Same thing regarding a notice of appeal. If an injunctive order, including an interim injunctive order like a TRO or a motion for preliminary injunction, if it includes a mandatory relief, right, something that requires the party to be restrained to do something, as a general rule, that is immediately appealable, whereas prohibitory relief is not. And it's not as simple as just looking with an uninformed eye at the relief requested, but focus on it very carefully. If you have an injunction, I'm going to make an obvious example just off the top of my head. Enjoin Ms. White from stopping building the retaining wall that she contracted to build. Well, that's the same as saying enjoin Ms. White to build the wall. That's a mandatory, it's an ill-disguised mandatory injunction. Immediately appealable means it stays the order requiring your client to do the act in question. Try not to miss it. Very quickly, because this will go tight on time here, consider any related litigation. Do we consolidate this case with another one? Do we low number it? In other words, take it to a court in which another action is pending between the same parties? Do we have an exclusive concurrent jurisdiction issue? If there's another lawsuit pending that involves the same cause of action, same claims or occurrence in the federal court, same primary right in California state court, you can't be in two courts litigating the same issue simultaneously. It's inconvenient. It could lead to inconsistent judgments, and the effect is you try to abate the second action in favor of the first. Susie?
Yeah. The next issue that you really want to think about, especially if you have a client or a case in a jurisdiction in which you are not licensed to practice. We do it pretty regularly, but of course you have to follow the rules and do what we call the pro hoc vice, where you get approved to represent the client in that case, in that particular case. It is not typically very complicated, but needs to be done, and you typically need to do it obviously before, or it's going to happen after you file your first appearance. So you need somebody licensed in that state, albeit another person from your firm that may be licensed there, or local counsel.
Some might say the purpose of the local counsel requirement is to ensure that your conduct and behavior in the court in question conforms to the court standards of practice and responsibility. Other cynics might say it's called the Local Lawyer Full Employment Act. I leave it to you.
Well, in Delaware, for example, you can't just use an attorney that's licensed in Delaware. You have to have a physical presence, an office located in Delaware as one of your counsel. So it is important to, build those relationships, have those, if you have, various jurisdictions that you may practice in a little more frequently. But local counsel can be, a little bit conflicted in terms of they start to try to take over the case. And then some are great, and they're just really helpful in giving you the unique, procedures that may go along with that court that because you don't regularly practice there, you wouldn't know. And I have found them to be extremely helpful in situations like that.
Next thing, confirm the presence of all necessary parties. If your client cannot receive complete satisfaction by a judgment against the named defendants, that's a real problem. So, for example, if the case involves, to make it simple, a piece of real property, make sure you name all the owners and lien holders on that property. Otherwise, you may have an incomplete judgment, you will have an angry client, and then the ramifications of that I leave to your imagination. We already talked about sham defendants, that's fine. Legal status of plaintiff, capacity to sue, standing to sue. You really got to look at that. In the class action context, we've run into cases where subsequent to the complained of conduct, the named plaintiff has died. It will come as no surprise that dead people make poor litigants, and the plaintiff will need to substitute in somebody like the estate or a something or other, or if they've lost mental capacity, arguably, they'd want to go for a conservator or a guardian ad litem. And so that's one thing to be considered in that context. I also have on my notes through bankruptcy filing. This is an interesting thing. There are certain kinds of cases, class actions challenging debt collection practices come immediately to mind. Other kinds of consumer class actions, you'll be shocked and amazed to learn that people who are suing because they don't like the conduct of a debt collector often owe money, and those people often file bankruptcy. Well, when you file a bankruptcy, you have to file something called a Schedule of Affairs, if memory serves, that lists all your assets, all the assets of the bankrupt, okay? And a legal claim is an asset. It's a chosen action. It has to be scheduled. What's the effect of having an asset as a debtor in bankruptcy that is not scheduled? The effect is either you amend your schedule PDQ or you have forfeited that claim and it belongs to the United States, which will deal with it on the behalf of creditors, in which case, if enough time has passed since the bankruptcy was filed, you can often buy that claim from the Chapter 7 trustee for a very nominal amount of money. So you got a new case, your client has been sued by Jane Bloke, get on Lexis or Westlaw or some similar service and confirm that Jane is both still alive and not in bankruptcy. It can be a little embarrassing if you don't. Even if you're sued and we've checked for personal jurisdiction in the jurisdiction in question, and we've assured ourselves that indeed Worldwide Volkswagen is subject to suit in Oklahoma, that's where the case is from, by the way, do we have a forum nonconvenience argument? Ms. White and I have moved cases across the country on the basis of forum nonconvenience. You're going to have to help me, section 1404, 1406, something like that. Run through it. Even if the case is properly in a district in which you've been sued in a federal court, can you move it somewhere else for the convenience of parties and witnesses? Or if you're filing one, let your client know that conceivably the defendant might attempt to move it somewhere else. There are a number of factors set forth in the test for forum nonconvenience. Also consider if your client has been hit by suits all over the country, is this a situation where an MDL, a multi-district litigation proceeding, could or should be sought? Also, is the case that's brought properly part of an existing MDL proceeding? You don't want to be the person who's off happily litigating in the woods of state wherever. If meanwhile in federal court in Chicago there's a huge MDL going on the same subject, and no matter which side of the V you're on, you've never raised that with your client, it can be embarrassing and expensive and problematic. Susie, how about attorney's fees? Something near and dear to everybody's heart.
Because that obviously can be a make it or break it when you're litigating. And again, it can be found in contracts, and where the prevailing party is entitled to recover attorney's fees. There's also certain states that if you have an attorney fee provision like that, that means you might have one that says party X would obtain their attorney's fees. The courts have interpreted it to be the prevailing party, regardless of whether it was a one-sided attorney fee provision or not.
And there are prudential and societal reasons for doing that,
right,
to prevent people from just severe overreaching without having to resort to the law of substantive unconscionability. Right.
But it's an important thing to consider first in contract, because it can have huge ramifications on your case. If you have, with all cases, risk of losing, if you're going to have to be not only pay a judgment but also pay their attorney's fees, that needs to be heavily considered, because
and disclosed
and
consented to.
Right.
Or else, you don't have to have been negligent to get sued for malpractice. All it takes is a dissatisfied client. It may be hard to prove, but it's colossally embarrassing, expensive, and there are a ton more adjectives I could interpose.
Right. Well, and the important other thing too about attorney's fees is, even if you don't have a contract specifying that prevailing party or what have you is entitled to them, there's also statutes that provide for the recovery of attorney's fees in certain cases.
Civil rights, environmental, public benefit cases.
Insurance bad faith.
Bad faith.
Yes. So in those kinds of cases, you need to know it enough so that you can, if you're the plaintiff, so that you can make the plead for it, because like anything, if you don't ask for it, you don't get it. So.
And during the pendency of the case, don't forget the attorney's fee provision. Had a case years ago, and the other side made a few missteps and was subject to a motion to compel and discovery, and I was of the opinion they hadn't complied with the court's order. So we brought a motion for evidentiary issue or terminating sanctions, and while that motion was pending somewhere in the briefing process, rang up the other side, asked the other side what their opinion was of our chances of success on that motion, was told 10%. I said I thought it was slightly higher, but in any event, do recall that we have a prevailing party attorney's fee provision in our client's respective agreement, and was opposing counsel of the opinion that having his case terminated for misconduct would make me the prevailing party. Then I pointed out to him that our client had incurred about $800,000 at that point in attorney's fees, and had he advised his client of the possibility, 10% as he put it, that his client might owe my client $800,000, you'll be shocked and amazed to learn that they dismissed the case shortly thereafter while that motion was pending. Susie, background on the judge.
Yes, this is not only just a strategic, important, helpful information to have, but it can actually be an important part of the case. When you get your assignment of your judge, which usually happens within immediately or within the first couple days of having filed your case, you want to take a look. Do a panning of your colleagues to find out what their experiences have been with that judge, especially even hone down on that in this particular area you're on, a breach of contract or a lease breach or something like that. Find out what experiences they have, because they can be very helpful. If you're in federal court, it's still good to know, but you get what you get, you don't get upset. But in state court, you have a certain time, at least in California, to do what we call the peremptory 170.6, where you can, for no reason at all, you have one shot of dumping that judge. And if I bet you've used it, I know I've used it, and you hope that the devil you don't know is going to be better than the devil you know.
And when you do have a peremptory challenge, consider whether the other side is also going to exercise that challenge. Only one is required. You may even ask opposing counsel if they intend to challenge Judge Jane Bloke because she's notoriously terrible. And if you get an affirmative, hey, let them do it, because then you still have your challenge if you get assigned Jane's
Right.
sister after that, right? So there are a few things to keep in mind there. There are other things you can do, but Ms. White mentioned breach of contract cases, lease cases, that kind of thing. There are some where the personal predilections of the judge and prior rulings or stuff you can glean about them can be incredibly important. And I will offer stuff up to you like environmental cases, civil rights cases, personal freedoms cases, political question cases, things of that kind. And it may well be revealed to you in the basis of your research that it might be a very good idea to get the hell out of that particular courtroom, even if it involves dismissing the case and trying something else. I leave the details of that.
Well, and
to
the
your
other thing to
consideration.
do background on is your
Please.
opposing counsel. And not to say you get to select them, I mean, but just sometimes having insight on how they behave and what sets them off, how are they maybe not as credible or trustworthy as so you're going to change your behavior to make sure, for example, that everything is in writing, so you don't have to worry. Sometimes they'll say no, they're so above board. You can, not that it certainly anything super important you want to make sure is always in writing, but you don't have to have quite the fear that they're going to turn on you and say, they said X when they said Y. So those kinds of things can be just very helpful in your going on day to day. Also, sometimes you'll find out maybe that your opposing counsel knows, Jane Bloke in your firm. Having that connection, mentioning that, oh, they spoke highly, it could be, having a good working relationship can be very helpful on a case. Back in my early days, we saw them as the arch enemy, our opposing counsel, and everything we did. And we'd notice the partners could come in and argue about the merits of something, but then be very friendly. And I felt like it came with experience that you can separate those two things. So.
Even if it's bad news, it's better to know it up front and to tell your client about it up front. And the most famous decorated military officer in U.S. history, General Chesty Puller, fighting in the Korean War, sent a report back to Washington saying, "We have been searching for the enemy. We have found him. We are surrounded. That makes things considerably easier."
It's
so
not funny. I'm
well,
sorry.
I think he was only half kidding.
Right.
In any event, so experts, early retention of experts, not necessarily testifying experts, but what can they do? How can they help?
Right, and this is something too that can have a big impact on how you frame your case. For, again, I'm using the insurance example. If you have an insurance bad faith case, you would be remiss to not hire, if there's fees involved, you want to have an expert on the fees. If with bad faith, there's claims handling best practices or accepted practices, you want to have somebody helping the jury with that. And it's better to not wait until you're up against an expert deadline and all of a sudden the one you want to go to is too busy, or you're talking about issues with them and you figure out they're not the right person. The time to do it is as soon as possible, if you know that an expert is in the realm of something that would be helpful to your case.
And so, very quickly, selection of experts, right? Consulting experts, you never have to disclose their work product or what you've given them. Testifying experts, you do. Say there are two terrific people you've used. Consider which one you might want as the testifying expert and which one you might want as the consulting expert. If you're the plaintiff, consider involving them in the stage of the drafting of the complaint. They can be tremendously helpful. And so, I'm a sailor, right? When you retain an expert in litigation, it's the same as when you reef, when you shorten your sail, right? The answer is always before you have to. All right, so we offer that, and again, that's something to discuss with the client. It shows you're giving the case thought. You're already thinking forward towards battles over the pleading, towards discoveries, towards trial. Next topic, consider whether any regulatory agency should be informed about the existence of the action, whether plaintiff or defendant. They may wish to intervene. consider whether they would wish to intervene. Consider what would happen if they did. Consider whether, if you're the defendant, the action should be abated under something like the California primary rights jurisdiction. If the action poses a complex issue of regulatory law that you believe is unsettled, are you of the view that you'd rather have the agency weigh in on this rather than the court? The court might agree with you, and in which case the action can get stayed pending a review by a state regulatory agency. The other issue I would raise is consider whether any policing agency, and by that I mean any enforcement agency, including the United States Department of Justice, the California Attorney General's Office, or similar enforcement agencies, should be notified about the proceedings. That could be a double-edged sword. It might result in some kind of criminal investigation on their part, which would ultimately have the effect of staying the civil action in which you're involved. That can be a nice thing if you're the defendant. It can be a not so nice thing if you're the plaintiff. I would also be remiss if I didn't caution that you cannot threaten the other side with seeking law enforcement or other governmental intervention in order to gain a civil advantage. I have on my outline an application of claim splitting doctrine and exclusive concurrent jurisdiction. I think I've covered that already. I think Susan covered that with me already. One thing that I wanted to emphasize is a cause of action is not always what it looks like or how it is pled, and you should always consider the possibility that a cause of action is disguised either purposefully or unintentionally. So if I'm faced with a complaint that appears to recover money under some state court theory or even a federal theory on the basis of improperly having obtained money from a federal payor, a federal program, because my client's party to some complicated, say, provider agreement that services Medicare Advantage patients, and really only private parties are involved and no government entity. But if the genesis of the complaint is that we've not acted in accordance with federal statute or regulation, and as a result obtained money even tangentially from a federal program, then really ask yourself, do I have on my hands a disguised Federal False Claims Act case with its own requirements, including filing under seal and all kinds of things like that? And by the way, it would also create federal jurisdiction. That alone could do a 2-hour CLE, but it's worth considering. Do I have disguised claims or causes of action? By the way, more often than my False Claims Act analogy, you often see that where somebody attempts to, as a judge once put it, tortify a breach of contract claim, right? So you can seek the expanded benefits under a tort claim as a plaintiff rather than under a simple breach of contract claim. By the way, if you have a case that asserts what is primarily a breach of contract claim but has a few tort claims thrown in, and you gleefully assume you can get them dismissed, and maybe you can, you may have just dismissed yourself out of insurance coverage for the defense of the action, which usually does not cover breach of contracts claims but often covers tort claims. So give it a little heavy thought. This is a client disclosure and informed consent issue before you go ahead and you shoot their insurance coverage in the head during the case. Do you agree with that as an insurance lawyer?
I do, and in fact, jumping from there,
please,
is, one of our next points is considering and advising the client about the possibility of available insurance coverage. Now that may be, you may not know if there's any coverage, you may not have any idea what your client has in the way of coverage. If they have been sued, and something important to remember, even if they brought the action, if a cross-claim or counterclaim comes back at them, and this is where a lot of people sometimes don't think about it, even though they are the plaintiff in the original action, if they're getting a suit back at them, that's the time to tender it to any potential insurance. And as a lawyer, again, going back to the informed issue, we would highly suggest that you have in writing the inquiry to your client about potential coverage, because it can be malpractice to not discuss and inquire about available coverage for any litigation.
I agree with that totally.
And so it's really important. And above and beyond everything else is if you can find coverage for this, lawsuit, I mean, first of all, you're going to be, in the best, situation for your client, because these cases, as we've talked about already, can be so expensive. And if you're getting, that paid for, the client is just going to be so much happier, and it's just such a great thing. And, again, I'll take my plug. Insurance companies don't always do the right thing. So don't just blindly accept a denial. And if you need, an expert to take a look and see, do they have, is there arguments for coverage? Don't hesitate to do that, because it can be the difference of millions of dollars.
All of that's true, and I'll take it back to the pleading stage. You're pleading the case, you represent the plaintiff, you're about to file a lawsuit, you are the master of your pleading. Consider, do I want to plead this within coverage, or do I want to specifically do it to prevent coverage? If you have that availability of information as to the defendant's insurance, which, by the way, you might often have. Your client, as plaintiff counsel, might be a former officer of the company, might know quite well what kind of insurance is available. You're suing on behalf of a former COO, for example, or CFO. Find out what the coverage is. It can make a big difference. Another way to get serious egg on your face and potential problems, or to potentially great advantage, is consider at the outset of the case, if you're the defendant, are there any cross-claims that are available? Counterclaims, as they're called sometimes. Does defendant have a gripe, a legal gripe, legally cognizable gripe against the plaintiff? If so, are those permissive or mandatory? If I sue Ms. White over the retaining wall that she has woefully and intentionally failed to build, she could probably cross-claim against me for damage to her car. That would be a permissive cross-claim. You don't lose it if you don't bring it. But if it's related to the same transaction or occurrence, to use the federal parlance, and it's not brought, it might be lost forever. Knowledge, find the issue, spot the issue, all of these. Again, this is a checklist. This is here for you, right? And if it even saves one of your people or yourself one false step, it'll be worth everything you paid for this program. And I'd like you to also send me personally a check at the address that we'll give you at the end of the program. Make it payable to the Brennan Struve Children's Trust. It's children's in the plural, possessive. Other things to hit on, very important. There are a few other items on this list that we will not be able to get to, but I do think we should raise the issue. Document hold and preservation, so important, okay? And then in the context of client communications, when you interview the client, when you talk to the client about the case, upjohn warnings and giving notice to officers that you represent the company and not them can be colossally embarrassing if not done. Susan?
So what another really helpful thing to do at the beginning of the case is outlining, first of all, what is it that you have to prove in this case? And it sounds so elementary, but very few lawyers do it as a matter of course. To actually break down, and a lot of times it's great to get the jury instructions and go through them and figure out what is it, what are my elements of proof that I have to demonstrate? And under that, what is the law on that topic? And what is the evidence that I have or need to try to prove each of those elements? And I know, like I said, it sounds so simple, but that can take, that can be the most important. The other, I would say, great thing to do if you can is, and you may not have it refined right at the beginning, but start thinking about themes of your case. What is the theme that's going to resonate with the judge or the jury about how my client has been wronged or has not wronged the other party at all? So those are really helpful things to spend time doing at the beginning of a case.
I think that's absolutely right. And I hope this has been helpful to everybody. And again, the document has a few additional topics on it. I recommend it to you. You've paid for it, and it's offered with our compliments. Any questions, we'll give you our email addresses, and you're free to reach out after I clear conflicts. Mine is, so it's Andrew Struve, S-T-R-U-V-E, at Hooper Lundy and Bookman PC. My personal email is atty.struve, S-T-R-U-V-E, at gmail.com.
And my email is swhite, all one word, at Buchalter, which is BUCHALTER.com. And yes, we'll welcome any questions you have or if you want to discuss any of the issues.
Thank you for your time.
Thank you.